I think I want to do a report. I don't want to make this bigger than it is. I could sentence now, but she needs to get printed and photographed.
I think to the discretion of the court, Your Honor, we were looking for some type of resource to assist her in identifying the cognitive behavioral.
Ma'am, are you married? Ever been married?
Years ago.
Do you have, how's your financial situation?
Okay.
I mean,
It's social security.
Your name.
Deborah and Lennon.
Judge, city,
good.
for purposes of arraignment, my client stands being placed from a reading.
All right.
Judge, we do have a proposed stipulated plea form that we tendered to the court. We're going to ask the court to consider a delayed sentence. 6 to 12 is what's being referenced in the report. She only has one, I think,
Impaired charge before, right?
years ago.
Is that what you want to do, Ms. Lennox?
Yes.
If you plead guilty to retail fraud, I'll take it under section 771.1. I will set terms and conditions. I'll set a period of probation between 6 and 12 months. And if you're complying, I'll be more than happy to dismiss the case on motion to prosecutor. Do you understand that?
It's what we do.
You're the conviction will enter now. The conviction will enter now.
Okay.
I'll put you on probation. If you're compliant at the end of the probationary term, the prosecutor who offered you this is going to move to dismiss. Do you understand that? Is that what you want to do?
Yeah.
And did you sign an advice of rights and read it and understand it here today?
Yes.
If you plead guilty, you'll be giving up all those rights and there will be no hearing or trial. Do you understand that?
Yeah.
All right. Do you have any questions?
Yeah, these are things that we went over. She's just a little confused and upset
Okay.
that she gets it.
All right. Meaning to the charge of retail fraud, how do you wish to plead?
Guilty. Guilty.
Were you in the city of Flat Rock on Telegraph near Leonard and Flat Rock on August 23 of 25 at 7:34 p.m.?
Yes, sir.
What business was that?
Dollar Tree.
And what did you do when you went into the Dollar Tree on that store, on that date?
May I, Your Honor? On that date, time, and place as stated by Your Honor, was this place open to the public?
Yes.
Did you retrieve some items of value?
Yes.
Okay, and did you exit all points of purchase without paying for those items?
Yes, sir.
Defense is satisfied, and this was your intent? It was your intent?
Yes.
What did you take, man?
Food.
Pardon?
Cat food.
Yeah, we're going to be asking that the court, as a condition, order a mental health evaluation.
Do you have a cat?
Several.
Pardon?
Several. I feed an outside community. Okay. People helping strays. I know it's so.
So you went in to steal cat food that you feed to your cats and stray cats? Am I understanding you correctly?
Sure.
What was the value of that cat food?
Not very much.
There's a receipt in here, Judge. I saw it. I believe that item were recovered.
Yes, they would.
$13.63.
Yeah, we're asking for a mental health evaluation. My client and I are both in agreement. We need to figure out what's going on cognitively with her decision making. She's 65.
Yeah. I'm basically a good person, just said it was a little bit of bad that comes out. I don't mean why. I'm not from it.
I think I want to do a report. I don't want to make this bigger than it is. I could sentence now, but she needs to get printed and photographed.
I think to the discretion of the court, Your Honor, we were looking for some type of resource to assist her in identifying the cognitive behavioral.
Ma'am, are you married? Ever been married?
Years ago.
Do you have, how's your financial situation?
Okay.
I mean,
It's social security.
all right. I'm gonna give you a personal bond of $500, okay? You don't have to post any money. You cannot leave the state without the consent of the court or violate a law. You must appear in court as directed. No contact with employees of the Flat Rock Dollar Tree. Or prosecution witnesses. You're not to enter that Dollar Tree store in Flat Rock or any other Dollar Tree. You cannot leave the state without consent. You cannot violate a law. You must appear in court as directed. You have to go to Flat Rock to be fingerprinted and photographed. And I'm going to have them do a pre-sentence report. Have you ever had mental health treatment, ma'am?
No.
All right. Let's do October 2nd, Lisa. Is 8:30 good?
What day is that?
I can look at it.
Sure.
It should be fine.
Let's make sure.
October 2nd at 8:30 will be the date.
Thursday.
That's,
Ma'am, you have to go over and get fingerprinted and photographed at Flat Rock today.
The police department.
where's,
They'll explain it to you down the hall. They're going to give you the order. And I mean, I don't want you to lose sleep. You're certainly not going to jail. We just want to get you some help here, okay?
yes, sir, that's what I want.
All right. Do you have any questions? So you go down the hall, pick up your notice, and then go over to probation right across the hall where they will interview you, okay? All right, good luck. Thomas Stephen Chapman, 25B149-246A and B.
Thank you, Judge. Again, House Counsel Attorney Mike Baldwin on Mr. Chapman, servicing approach the podium, please state your full legal name for the record.
Your name, sir?
Stephen Chapman.
Judge, for case A, the arraignment, my client stands mute with formal reading of the general information.
All right. I'll enter a not guilty plea.
Judge, we're going to adjourn this to allow the prosecutor to reach out to the complaining witness as to any potential out-of-pocket, direct out-of-pocket expenses. I'm going to ask that both A and B, realizing that B is a ticket, that these both be adjourned simultaneously together.
I don't believe he's ever been printed on this, so he has to go over to get printed at the Brownstown Police Department by 1 p.m. today, September the 18th. So I'll give you a personal bond of $2,000. You cannot leave the state without the consent of the court. You cannot violate any law or ordinance. You must appear in court as directed. No contact with the victim. No contact with prosecution witnesses. You have to go over to the Brownstown Police Department, be fingerprinted and photographed by 1 p.m. today, okay? We're going to give you an order for that. If you want a lawyer going forward, you're going to have to fill out a petition for one. I have to be, first court date, everybody's entitled to a lawyer, okay? And then the question is indigency. So I will go ahead and give you a date. Is it October 2, Lisa?
This is a Brownstown, October
I'm sorry.
16th.
I'm sorry.
October 16th at 8:45.
October 16th at 8:45 will be your next court date, sir. So you're going to go down the hall, you get your court date, you will get your order for prints, you'll go over to Brownstown, okay?
Judge, I'm going to hand him that form. There's a civil liability component to this case, and I think it would be paramount that, especially when the vehicle was owned by Chrysler, it was a work vehicle. I'm going to ask him to fill out a petition for a court appointed attorney. I think it would be essential.
How much do you make at Chrysler?
Yeah.
Where do you work?
I work for a defense company, but I just hired in local 1102 to get lawyer advice.
To be a what? Okay. All right. So you fill that out, go down the hall and get your notice and take your order over to Brownstown. Good luck.
Thank you.
We'll see you on the 16th.
Yes, you can, Judge, he can sit at this table and fill out the paperwork, correct?
Sure. People against Charles Christian Saracen, 25R 514-180, 25R 514-001, 25R 514-237, 25R 514011.
All right, my client's sit.
Yeah, absolutely.
Morning, Your Honor, Mike Hillcroft, referee there.
Your name, sir? So he has one misdemeanor outstanding, anti-blight ordinance. Does he stand mute, waive formal reading on that?
Correct, Your Honor.
Not guilty, pleas entered. He's had these other cases outstanding. I'm going to give you a personal bond, Mr. Sarazin. You cannot leave the state without the consent of the court. You cannot violate any law or ordinance. You must appear in court as direct. So I'll give you a personal bond. You don't have to post any money, but let me just cover one other thing with you. It says you're requesting an adjournment for compliance. So we're going to do
What, 30 days, Your Honor?
Give me somewhere close to 30 days, Lisa, please. This is
October 16th at 9 o'clock.
October 16th at 9 o'clock. Now, I want to caution you though, sir. You do have outstanding tickets here that are going to need to be paid. You have 198 plus 198, which is what? 396 plus 165. So you're somewhere in the neighborhood, 496.5. 56, it looks like 561. So somewhere in that neighborhood, you're going to have to pay those. You understand that, sir? Now, these tickets, he's letting go. I mean, he's got June 23, July 21, June 9th. He's going to have to figure out a way to take care of this.
He's aware, Your Honor. He's going to be working on coming in with something for a payment arrangement.
If you want a court-appointed lawyer, you fill out a petition for one, sir. Do you have any questions? I can't hear a word you said. Okay, good luck. And then you'll go down the hall and get your notice. Thank you.
Fill out the highway portion.
Do you have anything else ready or no? Or are we're almost done?
Yeah.
Caballero? Why is David Caballero? 25T6463339. Name?
Scapularo, Your Honor.
I have a charge that you failed to attend your scheduled probation visit on September 2 of 25. If you plead guilty or if you're found guilty, that would be your first technical violation. You could get 5 days. Do you understand that?
Plead guilty with reason, Your Honor. I understand, sorry.
All right, you understand that? And did you sign the advice of rights and read it and understand it? You plead guilty, you'll be giving up all those rights. There will be no hearing or trial. Do you understand that?
Yes.
You wish to have a lawyer represent you? I'll give you one if you want one.
No.
You sure?
Yes.
To the charge you failed to attend your scheduled visit on September 2nd of 25, how do you plead?
Guilty with
Did you fail to attend? Why? How? For what reason?
in jail or in the hospital.
What's that?
I was either incarcerated, still in jail at the time of the,
You have proof that you were in custody during that time?
Had proof of incarceration.
Here's what I'm gonna do. I'm gonna go ahead and enter a not guilty plea. I'll give you some time to go get that information.
Still didn't show, I still didn't report that. Maybe could have told,
Just listen to what I'm telling you. Just listen to what I'm telling you. I want proof that you were in jail or in the hospital on September 2nd. So I'm gonna enter a not guilty plea, okay?
Okay.
I'm gonna enter a not guilty plea. I'm gonna give you a $250 bond. You cannot leave the state without the consent of the court or violate a law. You must appear in court as directed. Do you understand all that?
One thing I cannot afford the $250 bond.
There is no bond. I'm giving you a personal bond, okay? I'll just make a note. Defendant said he was in hospital on 9/2
I
or
believe I was incarcerated.
in custody.
Yeah.
To bring proof. Mr. Listen. Aren't you going to get tired of going to jail?
Speaking in all honesty to you, and you're an honorable man. I've seen had many days of here, and I believe more honorable than some judges I've been in front of. And I'm talking about Ms. Hope.
I don't need to talk about me or other judges. I just want you to know, aren't you tired of going to jail?
Yes, Your Honor. I just got out of Metropolitan Behavioral Health I think that you should know about it. I think other people should know about it. It's through Corwell and United Health Service. I have not felt this clear-minded since I left.
Good. Do you have a report from them?
Still current, I don't have a report from them.
Okay, get it.
And I'm still currently under partial hospitalization. And they were supposed to pick me up this morning. This is a godsend. I didn't even know I had to show cause today. And they were supposed to pick me up this morning. They didn't. For some reason, they missed it. And then my mother was taking me and she got really thrilled while she was taking me. So I decided I didn't want to be in the car with her that long. So I decided to come into the courthouse, and that just so happened to be my show cause. And I'm taking responsibility for what I've done. I'd like to get on the right track and move forward with my life.
Well, that sounds good. You were so young. How old are you again? If you behave yourself, you're gonna have 50 more years on the planet, at least 40 some.
Behavior.
Okay, well, that's fair. All right, Lisa, give me another date. I want you to go get proof of this, okay? What day are we gonna do this with him?
September 29th at 9:15.
Is that gonna give you enough time?
Yeah, I have to go there Monday through Friday.
Fine.
30 to 2:30.
September 29th at 9:15, bring proof that you're either in custody or in the hospital at the time of your probation visit, okay? All right, best of luck. Stay just one day at a time.
I just went to the A meeting at Way Serenity last night at 8:30. Got my 24 hours open.
Great. Just work one day at a time.
Can I say something off the record?
Well, everything's on the record. I keep. All right, take care. Good. Are we already done?
We're almost done. We're almost there.
Tiffany Janelle Epperson, 25W8395557A and B. Epperson. We're going to issue a show cause on this. This is a first miss on the A file, so we'll issue a show cause, default judgment on the other file. People against. 49322, 25B149311A and B. Counsel, your appearance.
Good morning, Your Honor. Kenneth Thompson appearing on behalf of Tia Marie Trucking. Good to see you, Judge.
So on file 311A and B, as I understand, there's going to be a plea overweight with agreed upon fines and costs of $2,100. And then on 25B149322, there's going to be a plea overweight with agreed upon fines and costs of $1,500. True?
That's correct, Your Honor. And I do.
You authorize sending those pleas on behalf of the company?
Yes, I am authorized, Your Honor, to accept those pleas.
All right, on file 311A, to the charge of overweight, responsible or not responsible?
Responsible.
And then I'll accept that plea. Dismiss file B, which is defective equipment, fines cost $2,100. And then on 25B149322, to the charge of overweight, responsible or not responsible?
Responsible.
All right, I'll accept that plea, $1,500 fines and costs. So it's $2,100 and $1,500 respectively paid by October 18th. Okay? Have a
Very
great
good.
day. Thank you.
Thank you very much, Your Honor. Thank you.
People against Saracen, Charles Christian Saracen, 25R514011, 25R514237, 25R514180. And I have another file. I'm sorry, 25R514011.
He's the sitter,
That's fine. 25R514237, 25R514001, and then I also have 25R514180. Your name, sir?
Charles.
You have an anti-blight charge and an inoperable motor vehicle. This citation was issued September 2nd. And then you owe money on 3 other cases, according to our records, $198, $165, and $198 respectively. So on 011, $198, 237, $165, And on 001-198, you have the right to a lawyer. Would you like an attorney? Okay. You can go out in the hallway and we'll set you up with an attorney. And then you'll speak with him or her, and either way, you're coming back in here, okay? Thomas Stephen Chapman, 258-149-246 A and B. Morning, Mr. Baldwin. What case do you have here?
Hold
Your name, sir?
on.
You're charged with moving violation, causing serious impairment, causing a broken nose, and then you also have, that's on file A. And then you also have disobeyed traffic signal. You have the right to a lawyer on these. Would you like a lawyer?
Yeah.
It's up to you. I can't answer that for you. You didn't go to law school, right? Something like this, I would get one. We'll set you up with a lawyer. You go have a seat out in the hallway and he will set you up. People against Marcus Talafaro, Lovett, Fuller, 24B-146-740A.
Thank you, Your Honor, and good morning. For the record, House Counsel Attorney Mike Baldwin on behalf of Mr. Fuller, sir, please state boldly for me.
Mark Stoker, that law school.
Thanks, Judge. We're back today on this sentencing on the
I'll put Beth in here. You need Beth. Okay.
I believe there were two considerations that the court wanted to emphasize completion. And one of them is he was to test. He did. He's compliant. Number two, he had the OWI, and Your Honor wanted him to clear that warrant. He has other outstanding warrants, and he's working through those. He's due to.
All right. Let me just get the probation director over here, but I want to just summarize here. He was here on September 4th.
Correct.
There was a charge of failure to submit to twice monthly testing as ordered on August the 5th,
Correct.
and failure to clear all warrants. Those were the two charges, correct?
Yes, and then of particular interest to Your Honor was the OWI that you wanted addressed immediately, and if we do that, and he also was tested, and he was reportedly
All right. And he pled guilty to these two charges, or at least was found guilty. I don't remember if it was a plea or a finding. And then I told him to test that day. Ms. Reynolds, your name? Can't read my own writing. Where did I order him? On site, right?
Yes.
And then I set a sentencing for this morning at 8:45, and I said he was going to, it said, or at least my notes say, it appears he's going to 34th on September 15th. Did he do that?
Yes, I did.
What happened on that?
They set another court date for October 16th.
All right. Was his test negative?
His test was negative and he went as with the judge.
And what's your next court date, sir?
October 16th.
Moreover, Your Honor, you may remember he was paying an inflated rate of apartment rent. He lost that apartment, so now he has more money, and his objective is to funnel that in these warrants, predominantly at the 36th district. He's due to discharge in March of next year, so he has a plan to have all of these warrants cleared.
What was the offense date on the drunk driving out of the 34th? Can you tell me?
Yes, Your Honor, March 27th, 2023.
All right, but he was not on probation at that time here. What do you think?
He's compliant with everything else. He's very active and engaged in treatment. Mr. Fuller, from the beginning of probation really has turned it around as far as he does communicate with me. He went for this test. Counsel's correct. It was negative at on-site. I think the issue is he's dragging the feet, and that might be financially motivated as far as clearing up the warrants. He has 9 total outstanding warrants, and now this pending pre-trial in Romulus on October 16th. So that's where we're at, but all the other terms and conditions, he's compliant with his SoberLink. Work program is completed, everything else VIP, again, has been very spot on.
I just want to check out the warrants. It looks like most of them at least.
I did print it this morning in preparation, Your Honor. I do have those highlighted if you want to see my printout.
No, that's okay. They're mostly for civil infractions, it appears, other than that one, correct?
That was the big concern was 34.
Right. All right. Any recommendation or anything you've?
At this point, Your Honor, I think a new date to clear those warrants, it sounds like according to counsel that Mr. Fuller, sounds like he probably has a plan. He's in a financially better spot as far as hopefully being able to take care of this stuff.
You realize you got a violation. I mean, a lot of those happen on one show cause. But I remember you. I'm never going to forget you. I'm telling you, some of the nonsense he pulled in the beginning.
What it appears his pattern of behavior is he'll get himself in a situation, he lets it just kind of linger and then he picks it up and then he starts moving with it. And that seems to be a pattern. So I think he's on track and he's moving through the probationary process. He has a plan. As you may recall, he has a very good job. I believe that's with Ford. So he is gainfully employed. He is stabilized. He has residency. So I'm going to ask the court to allow him to continue on probation, allow him to continue doing the things that he needs to be taken care of so he can take care of his business.
Anything else you want to say, sir?
No,
I'm just going to tell you that I need another page of a register just to staple it on there. The problem I'm having. Yeah, I'm having a hard time forgetting what you did in the beginning. I mean, just total distrust I have right now. Being said, maybe you're getting better. Maybe that was a wake-up call. You're to pay additional costs of $75. You're to serve 1 day on the court work program and pay $35 for that. You're to serve 4 hours of community service by October 20. You are to clear all of your warrants by October 31, Mr. Fuller. I expect them all cleared by then. Do we understand one another?
Yes, sir.
Okay. So he owes 110 on this, and we'll set you up on the court work program. But go ahead. Was there something else?
You just need to clear, getting the matter resolved to fruition with the court is not what Your Honor is looking for. The system will move at its pace. He just wants you to clear the warrants.
He's going to have to pay those civil infractions is the problem.
To clear the warrants.
All right. Can you pay the 110 now or do you need 10? Pay by, I'll just say. How much time? Can I just say by October 1?
It's fine.
By October 1. Okay. Thank you. Thank you.
Hey, guys.
You need to see him?
Juan Alexander Ortiz. Do we have Mr. Carmen on this case or?
No.
This is 25B148377.
Michael A. Carmen, 37384, we have the defendant.
Let's go for it.
Do I have a Jacqueline Alayan here? Do I have any employee of Brownstown Forest View or anybody from Brownstown Forest View? Sir, your name?
Alexander Ortiz.
Mr. Kerman, your client pled guilty previously under section 771.1 to telephone harassment. He was referred for a screening and for a pre-sentence report. Have you had the opportunity to review the report with him, and are there any material additions, corrections, or deletions?
Your Honor, I have, there are not at this time, but just something I want to emphasize that currently Mr. Ortiz is a stay-at-home father, has 5 young children, all of whom are in school. He's doing some side construction jobs, but he's got his hand full with his children. Otherwise, factually accurate and would ask the court to adopt the recommendations of probation, please.
I just want to make sure that Jacqueline Leon is not here, Lisa. She's not here.
No, not on Zoom.
All right. Sir, is there anything that you would like to say?
Apologize to the court and my family.
Do you think any of these actions were appropriate here?
No, sir.
I don't, first of all, the calling her at her business repeatedly when they told you not to call is unacceptable. Let's take that and multiply that by 3. You're continuing to call there after the police told you not to when they were at the property. On a scale of 1 to 10, that's a 10 that you still did that. You threatening to shoot up the place on a scale of 1 to 10 is 100,000. I don't understand these threats of violence out there anymore. In this day and age, when we got crazy people running all over the country that think that shooting people is fun, you don't threaten to shoot up a place. Maybe there's some demented human being in the world that would find that amusing. I'm not demented, and I don't find it the least bit amusing. Now, I'm telling you, you have any contact with that outfit over there, I'm telling you, you're going to jail for the rest of the probationary period that I can possibly give you. I'm sorry, for the balance of the jail term that I can possibly give you. Do you understand that? I don't even know how to handle this no contact. They have children. How are we going to handle that? He scares the devil out of me throwing.
We don't have children. Daryl's behind us. I'm not a threat at all.
You threaten to blow up a building and people.
I probably will never see that lady.
Your Honor, he no longer has any reason whatsoever to be in contact with the facility or anything.
I just don't know what to do with these anymore. I mean, somebody has a bad day and they think they can threaten people. I just don't get it. Probation 771. You cannot leave the state without the consent of the court. You cannot violate any law or ordinance of any unit of government. If you change your address, your place of employment, or home telephone number, you must notify probation immediately. You have to report as directed. You're not to go near Brownstown Forest View, 19341 Allen Road in Brownstown. You're not to contact them. You're not to call them, write them, text them, email them, go anywhere near them. You're not to have any contact with Jacqueline Leon. No contact with her at all. You're to attend a psychiatric evaluation and treatment if recommended. You're to attend an anger management program with 8-week follow-up. So again, you're not to go near Brownstown Forest View, 19341 Allen Road in Brownstown. No contact with Jacqueline or Leon. You're not to possess firearms of any kind. You're not to possess dangerous weapons of any kind. You're to obtain and maintain employment and provide proof, and you're also to obtain a high school diploma or GED. You're to clear all your warrants within 30 days. Five-days court work program, there's a $35 a day charge for that for a total of $175. Fines $100, costs $125, 75 victims' rights fee, $50 justice assessment, $350, screening fee $60 for 410, probation fees are $240 for 650. We have court work program fees of $175. Your total is $8.25. If you violate, your probation could be revoked. You could be incarcerated for 90 days. You have 21 days to appeal, 14 days to apply for a court-appointed lawyer. This could have been a lot worse. Do not do that again. Give me a review hearing date, please, Lisa.
September 3rd of 26 at 9 o'clock.
September 3rd of 26 at 9 a.m. Now, can he pay all this today? How much do you have today? I'm sorry? When are you going to be able to pay this?
In a week.
I don't need you to pay it all in a week. You pay $100 per week. How's that? And I'll start it beginning on September 29th. Can you do that? If you don't have the money, you come to the court. I'll be glad to give you an extension, or you call the court on it before the due date, and I'll be happy to give you an extension. Whoa, scary. Good luck. You'll meet with probation before you leave. Todd Rutherford,
Thank you.
25R253193. Good morning, Mr. Shemke.
Good morning, Your Honor. Mr. Shemke, appearing to get my client in Brooks, be standing behind the above.
Your name, sir?
Todd Rutherford.
This is a disorderly charge.
Yes, Your Honor, there's an company case of Brownstone as well. But as to this case, wait for reading my client's statement.
I'll enter a not guilty plea. $500 personal bond. You cannot leave the state without the consent of the court or violate a law. You must appear in court as directed. No alcohol. There being an allegation that he was disorderly because he was intoxicated, at least in part. No alcohol, no illegal drugs, no marijuana, no contact with prosecution witnesses except through your lawyer. You cannot leave the state. You cannot violate a law. You must appear in court as directed. You understand all that?
Yes, sir.
Do you have any questions? And we're going to give you October 16th. That's when you meet, right? Or
Yes, Your Honor, I was going to ask for the second, but I spoke with the prosecutor for Rockland. He's not here on the second.
that's fine. October 16th, please, at
8:30.
8:30. Okay. All right. So you can go down the hall, sir. They're going to give you a paper notice and we'll see you back here. Do you have any questions?
Your Honor, I believe that there's one other company case, Mr. Rutherford upstate from there as well.
Todd Jeffrey Rutherford. This is file number 25B149205A and B.
Good morning, Your Honor. Mr. Shemke, appearing to get my client, who's against my legal.
Phone.
Whose phone was that? I'm sorry.
So we got another disorderly public intox.
Yes, Your Honor, these the defense dates were back to back.
And then says he's got and we also got an animal cruelty case going.
Yes, Your Honor.
Do you have any idea what the allegations are?
No, Judge, we're getting the rings.
Keeping or harboring an animal in the kennel or otherwise willfully or negligently caused or permitted the animal to suffer unnecessary discomfort or pain.
If I were to speculate, Your Honor, I believe that my client was driving, we're waiting on a blood alcohol level come back, and I assume that there was potentially an animal in the vehicle, but the animal was not injured.
But they've got another one here. Left his dog in a 2016 Dodge Ram. Vehicle was not running. The windows were up, the doors were locked, and the engine was off. Dog was beginning to show signs of distress due to the high heat index. Defendant refused to assist police in safely removing the dog. Police had to break the right rear window of the vehicle to remove the dog in order to ensure it would not continue to suffer unnecessary pain or discomfort. All right.
As the arraignment way forward, we might stand still.
He's got a super drunk charge.
So good.
Where's the dog at now?
Oh, she's at the house. My dog is very well taken care of, sir. My dog loves me.
I don't want you to talk about the case at all, sir. You shouldn't. But this was August 6th. Now, unless we were having an unseasonably, and I don't want to talk about it, cool day for August 6th, that would be completely inappropriate. So let's just back it up here. Where's the super drunk charge?
It's in Brownstown, Judge. I've spoken with Ms. Caitlin Foley. We anticipate that case coming to fruition before the next.
Is that in front of me or Judge Hessen?
Judge, it hasn't been,
Charge.
hasn't gone forward yet, but with the blood alcohol came back, I believe, I spoke with Ms. Caitlin Foley, indicated that there'll be a date that it happens. The court, we're gonna walk him in immediately after, so we'll be seeking to put the
I need another bond sheet, please. Are you married, sir?
No, sir.
Is there anybody else that lives at the residence with him, Mr. Shemke?
No, Your Honor, I know that he was married. He has fostered and kept good relations with their stepsons and they're grown, and they don't reside with him.
This is getting a little bit more serious than I'm anticipating. What's your dog's name?
Sapphire.
These are all separate offense dates, were they not?
Yeah, nothing close to 570, but 7 days.
All right, here's what I'm going to do. I need everybody to just give me 1 second here. All right, on the B file, 205B, because I'm setting separate bond conditions, these are the bond conditions on this. You cannot leave the state without the consent of the court. You cannot violate any law or ordinance. You must appear in court as directed. I'm going to give you your date again momentarily. You're to attend AANA twice a week. We're going to give you a form. You have to go in person. Every time you go, you have to have the form signed. Every time you come to court, you have to bring the form with you. You're not to have any contact with prosecution witnesses except through your lawyer. You're not to own, possess, or harbor any domestic animal other than that dog. So you're not to acquire any other dogs. You're not to own, possess, or harbor any other domestic animal other than that dog, Sapphire. You're not be on a SoberLink device by the end of the day. SoberLink device by the end of the day. I'm going to give you a court date, which is going to be on September the 18th as well on this one, Lisa. I'm sorry, on October the, what day did I give you?
October 16th, Judge.
I'm sorry?
The October 16th.
October 16th. And what time did I say on the other one, Lisa?
8:30, Judge.
Thank you. So that's when I'm setting all of these. October 16th at 8:30. And we will go from there, okay? Sir, do you understand all your bond conditions here?
Yes, sir.
Do you have any questions?
No, sir.
Okay, so you can go down the hall and get your notice. You're all set. Make sure you go to AA. Make sure he gets on the SoberLink by the end of the day.
Understood, Judge.
He can talk to probation, okay?
Understood.
Thank you. Martin Paul Stewart, 25F244536. Good morning, Mr. Robinson. Your name, please. How are you?
Good, Judge. Thank you. For the record, Steve Robinson appearing on behalf of Mr. Stewart.
All right, so what have I got here? I got an impeding. The client needs to slow down.
Yeah, Mr. Kelly had indicated that to me, Judge. I will certainly pass that on.
Well, make sure he understands. I try not to get involved in what they're doing back there, but this one, I'm sorry. I don't even know if I feel comfortable taking this. What's he doing? I mean, does he want to be, if he wants to be a race car driver, tell him to get on the NASCAR circuit. I'm serious. He's got a horrible record. Yeah, I'm sorry. I'm going to let you appeal or tell everything. I'm just not going to do this. I'm sorry. It's nothing personal. You know that. He's got 10 traffic citations on here. If he wants to be a NASCAR, I'm not going to do anything to him.
Okay, Judge, can we just set it for a formal hearing, I guess?
Sure. I'll be glad to set it for a formal. Tell Mr. Cayley, Don, I'm setting this for a formal, okay?
Which case is this?
In fact, ask him to come in. All right. Lisa, give me a formal hearing date on Flat Rock's docket, please.
October 2nd at 8:45.
Judge,
Yeah.
I thought I had my calendar next to me. Could the court give me about 10 seconds to grab it?
All right. Take your time.
He's on the plan.
Good morning, Mr. Cayley. How are you? Your name?
What the fuck can I have to see if I
I just can't take this to him. He's got too many tickets on here.
I told him he was pretty close to.
I mean, he's not only really close, he's way over. You know what I mean? I try not to say anything up here, but he's going to set it for a formal. So I just didn't want to blindside you. I'm going to tell you the date. It looks like if he's available, I'm going to do it October 7th at 8:45. This guy's got to learn to slow down. He's going to kill somebody or himself. Let me see what he just asked for about 10 seconds to see if he's available on that day.
Did you tell him the actual speed limit on that one?
I didn't mention it. It's 56 and a 40. But that isn't the point. Even if you go in 70 and a 40, but he's got like 12 of these on here. I mean, is it good that day, Mr. Robinson?
Did you say the second, Judge?
Yeah, at 8:45.
Excuse me. Yeah, that's fine.
And we should be ready to go, hopefully, right then, okay?
Sounds good.
All right, Mr. Robinson. Have a good day. Thank you.
No, Judge,
Thanks,
I
Mr.
understand. Thanks,
Thanks.
Roger.
Thank you. Philip Joseph Miller, 25R514288. Good morning, sir. Your name?
Oh, Bill Miller.
You're going to plead to impeding traffic, right? All right. You're going to dismiss the 5 over to that charge of impeding traffic. Responsible or not responsible? All right. I'll accept your plea. Dismiss the original charge. 170 is your total. You can go right down to the cashier end of the hall. Okay. Have a good day. Bruce, Matthew Wade Bruce, 25R514162 A and B. Good morning. Your name?
Good morning.
So you're charged with driving on a suspended and resist, hinder, and obstruct, and you do have the right to a lawyer. If you want one, I'll give you one.
Absolutely.
Would you like a lawyer?
Yes.
Okay. I'll be glad to give you a lawyer. You can go out in the hallway. You'll meet, he'll set you up with the lawyer. You just have to be patient. He's here. They both of them, I think, have a lot going on. So just be patient, okay? Thank you. And if either way, you're coming back in front of me, Rodney Trustler. Rodney Richard Trustler Jr., 22M307-186. Your name?
Rodney Trustler.
How come you're not? All right, I'm just going to go ahead. You're feeling, this was a case where there was a lot of restitution on. I ordered $5,567.42 in restitution. I now have a charge that alleges you failed to pay fines and costs, which includes the restitution. in the amount of $6,147.42. That was as of September 8th. That is the charge. If you plead guilty, or if you're found guilty, you could be incarcerated on this case for up to 5 days. Do you understand that? Did you sign the advice of rights and read and understand the rights? You plead guilty, you'll be giving up all those rights, and there will be no hearing or trial. Do you understand that?
Yes.
You have the right to an attorney. I'll be happy to provide you with one, whether you can afford one or not at public expense. Do you understand that? Would you like a lawyer?
Yes, sir.
You waive your right to a lawyer?
Yes, sir.
To the charge, you failed to pay your fines and costs and restitution as ordered, with the balance owing as of September 8 of 25 in the amount of $6,147.42. How do you plead?
Right, that's why my payments on there. Because
That's what they think it is as of September 8th.
so it should be 5 or less.
Pardon?
I just paid last night, so it should be 5 or less for that.
Okay. But as of that time, as of September 8th, how do you plead to that? Failed to pay as ordered? Did you fail to pay as I ordered you to pay it?
I was late on one payment. So, Your Honor,
Hang on one second. Call in and we.
I paid this off that I received.
You paid the whole thing off?
No, so the reason why I'm here is for a violation,
I know.
and I paid that.
Paid what?
There was like $500, so they wanted me to pay it within 30 days, and I paid that.
I told you all money was due on this by August 1 of 25. That's what I sentenced you to. This is September of 25.
Okay, but this was because of the violation. I just paid a $500.
Hang on a sec.
Sorry.
All I want to know is, do you have a balance of somewhere in the neighborhood of 6147.42 as of September 8th?
Yes.
So you're pleading guilty. Anybody forced you to plead guilty? No. Plea is accepted. Why have you not been paying?
Paid about $6,000. So
$6,000.
yeah, it was like $12,000 or something.
It was $10,847 because this was handled by the Attorney General's office, as I recall, was it not? And there was a minimum 5,000 fines. I felt bad about having to impose that, but I did. And then you had restitution of 55, 67, 42. Here's your problem. I can only keep you on probation for 2 years.
I think I have house being sold. And I'm probably gonna be able to pay everything off with that. I'm gonna assume within the next 90 days, so I can still make my payments.
I just want you to be aware. All right, let me get Ms. Tassino over here. What are you doing for a living now? Are you a licensed contractor?
Painting and flooring and nothing that's made.
Your name? What do you have to say on this? Anything? And right before you go on, Lisa, can you tell me the total balance right now? Is it in fact 56, 47, 42?
Yeah. Yes, it is. He just made a payment.
Go ahead.
Nothing else is done. It's just the money. I mean, I do see he's genuinely been making an effort. He's made several large payments. Just a lot of money.
I know. Put himself in a horrible position on this. All right, I'm gonna accept your plea. The failing to pay fines costs of $6147.42. I get the fact that that's before you made the $500 payment. I'm going to set a sentence date in this. How long do you think until you're going to have the balance?
I'm hoping with 90 days.
You got to have it paid by April.
April.
Wait a minute, let me just double check one thing. I want to make sure you're still going to be on probation.
Is there, that's what I was going to ask. I have the maximum probation time.
18 months. No, your probation is expiring unless I extended it on October 9th.
Yeah, can't keep them past after April 9th, 26.
April.
I know, but all right. I'm sorry. All right, here's what I'm gonna do. I'm gonna go ahead. I'm gonna keep you on probation. Probation's extended for 6 months until April 9 of 26. I'm not gonna order any additional costs. I'm not gonna order any additional probation fees. But you have to get some money in here. I'm gonna set a payment plan. How much can you afford to pay per week?
I mean, I'm trying to get so money doesn't come in every week, so I make $1,000 payment. I don't know what I can pay it. When I get it, I pay it, but I can afford. So it's almost like $200 a week is what we were trying to get. So when we talked about it, I told you that. So this house that I'm doing is still the same one. So when this house sells, I'll get a large amount of money. So, and it's almost done. So I'm hoping I should be able to have it paid off.
All right,
If we can stay on the payment plan that we've been doing, if I can get,
200 a week?
if I can get maybe 2,000 paid off in the next 2 months.
How about $200 a week starting October 6th and all money due by January 31 of 26? 200 per week beginning October 6th of 25. October 6th. That's about 2 weeks. And all money due by January 31 of 26. You think you can do that?
So let's, I'm hoping that as long as that house sells, and it will. So yeah.
If you don't have the money, that's what I'm ordering. If you don't have the money, you come talk to me on or before any of those due dates. I'll be reasonable with you. No, any one of these. If you're going to miss a payment of 200, you got to come talk to me.
So I'm here.
Right in here, on or before any of these due dates that you don't have the money in. So if you pay October 6th, 200, the same thing on the 13th, same thing on the 20th and the 27th, you can't pay. You have to come and talk to me.
Is there a chance I can?
Hang on. Or you can call the court and we'll go on Zoom on or before the due date and I'll do it by Zoom for you.
Is there a chance I could just lower it a little bit right now and then make the lump sum payment? It's just easier for me that way.
Lower it to help. Hang on. I appreciate the fact, even though what I thought you did here was wrong, I'm going to still tell you that I think I appreciate the fact that you've at least tried. I will do that a little bit for you here. Let me do this. How about if I take the weekly payments to 100?
Yes.
100 per week beginning October 6th, all money due by January 31.
Okay.
Every week.
So it's still the same amount.
What would I say initially? I said 200 a week.
200 every other week.
No, I said 200 per week initially.
It's 2 every other week. That's where probation.
Yeah, there was 200, but you can
Yeah, it was.
Well, it might have been initially.
Yeah.
I'm just saying now that there've been payments missed, we're running out of time kind of, right?
Oh,
I'll tell you what, I'll make it $125 bi-weekly. Beginning October 6th, all money due
thank you.
by January 31 of 26. So you have to start paying October 6th, all right?
Yes.
Good luck, sir. Thank you.
Thank you.
Marina Brabachevska, 25B14916 and B. And could I have Anaya Greer seated at the table here, my right, your left? Come on up to the podium, name. Your name?
Marina Rajewska.
You're charged with assault and battery and public intoxication. You have the right to a lawyer. Would you like one?
Yes.
All right, you can go out in the hall. We'll set you up. Just, you have to be patient, okay? They're dealing with plenty of people, all right? And then either way, you're coming back in front of me. Thank you.
Thank you.
People against Anaya Kenyatta Greer. Thought I called her. Did I call Greer? Oh, she's on Zoom. I see. 25 F244382. Name, ma'am?
Anaya Greer.
All right. You're charged with public intoxication. You have the right to a lawyer. Would you like a lawyer?
No, thank you.
All right. So on July 26 of 25, it is alleged that you did commit the offense Of disorderly conduct, public intox. They say you were highly intoxicated outside your aunt's apartment at 4:27 in the morning, and that you were kicking and banging and screaming at the door at 28526 Valley Creek Drive, apartment 505 in Flat Rock. That is a misdemeanor. It is punishable by up to $500 in fines, 90 days jail, costs for all of those penalties. Do you understand that?
Yes.
You're presumed innocent. They have to prove you guilty beyond a reasonable doubt. You have the right to remain silent, right to a trial by court or jury, right to question their witnesses, right to bring in your own. If you plead guilty at any time, you're going to be giving up all of those rights, and there will not be a hearing or a trial. Do you understand that?
Yes.
All right. Do you still wish to waive your right to a lawyer?
I don't feel I need one for this specific incident.
All right. I'm going to enter a not guilty plea. I'm going to give you a $500 personal bond. You don't have to post any money. I need a bond sheet. You cannot leave the state. Excuse me, without consent of the court. You cannot violate a law. You must appear in court as directed. No alcohol, no illegal drugs, no alcohol, no illegal drugs, no marijuana. You cannot have any contact with prosecution witnesses, and am I correct that you don't live far from your aunt?
No, we live right across the street from each other.
All right. All right, so I'm just going to indicate you have no contact with your aunt right now. Do you understand that?
Why is that?
I cannot understand the citation, but it seems to indicate that you were yelling and screaming at the door and pounding on the door of her apartment. So if she comes in next time and tells me she wants me to lift that, I will do so.
Yeah, because this incident involved my family, and the literal next day, we all made amends because they knew that, like, I was just overcoming postpartum. I went out and just got a little
Okay. You
excessive.
shouldn't really talk about the case. I'll tell you what, I will go ahead and lift that. I will lift that condition, but no contact with prosecution witnesses, no alcohol, marijuana, or illegal drugs. I'm going to send you into a breakout room shortly, but you just have to be patient. Why didn't you show up in person today?
Because when I received the notice, it said that I could either do it on Zoom or come in, and right now it was
Okay,
just...
I must have told my judicial clerk that too.
Yes, it was just easier for me today because I do have my child today with no babysitter.
I understand. How about in 2 weeks? Can you come in here? That would be what, Lisa, the 2nd?
It's October 2nd.
Yeah, can you come in here that day?
Yes, and
it's a lot easier when we have people here without lawyers in person. So you come in here October 2nd at 9 a.m. Is that all right?
Yes, I'm just a little confused on what's going on. I'm not.
You're being charged with a criminal offense of disorderly person, public intoxication. They think you were drunk. They think it was the early morning hours, sometime around 4 a.m. that you're banging and screaming at the door. I can't tell you anything other than that. That's all I know.
So right now, when you're telling me no alcohol and things like that, is it I'm being sentenced to probation and then you set the fine? What is that about as well?
You haven't been convicted of anything. That's a bond condition. I'm ordering you not to drink until we resolve this case or drug. Okay? Mm-hmm. October 2nd at 9, you're to be here in person. Okay?
Okay.
And all right. Best of luck. Any other questions?
Not at all.
Best of luck to you, ma'am. Deborah Ann Lennox, is your lawyer ready? Mr. Osmond, have you talked to the prosecutor yet?
Yep, I'm all set.
Oh, we got it. Okay, 1 second. What's your name, ma'am? Ashley what? Are you have a case here? Oh, were you just watching?
Yes, sir.
School?
Yeah.
What school? Nice. You can go back and tell him what a mean guy I am now, huh? Stevens Disposal and Recycling,
Yeah,
25B1494110 A and B. How you doing, Mr. Osmond?
Very well, Your Honor. Thank you very much. Yes, Jeff Osmond on behalf of Stevens Disposal.
A misdemeanor, you stand mute, wait formal reading, right?
Yes, sir.
And then you're going to plead your authorized interest. Washington. Jaquan Jalen Washington, 21W829-254 A and B. On the A file, defendant failed to appear. We're going to issue a bench warrant on this and forfeit bond. New bond. This is on, and I'm referring to the 254A file. Defendant's missed enough. New bond will be 6,000, 10%. This has been going on since 2021. And then on the other file, that's on the default judge, on the civil infraction charge. We're going to go ahead and indicate defendant failed to appear for show cause, applied bond. In other words, forfeit the bond, apply at the payment of fines and costs, and close this case, which is file 254B. So 254A will remain open, 254B will go from there. People against Chris Derrick O. Johnson, 25W839484A and B. On the A file, defendant failed to appear, will issue a show cause. On the B file, default judgment, people against Jason Andrew Bartel, 25W839334A and B. On the A file, 3,000, 10%. That was for failure to appear for show cause after so it's a second miss. And on file A, defendant was defaulted already on the 3rd of September. People against Lisa Marie Blair, 25W838228. Defendant failed to appear. We'll issue a warrant on this because this was failure to appear for a show cause, 3,000, 10%. Second miss, Keyshawn Deswan Hooks, 25W839402A and B. On the B file, warrant to issue bond to be forfeited for failure to appear for this show cause, 3,000, 10%. And the A file, defendant was already defaulted on. People against Eugene Laskowski. Eugene.
I do.
State your name again for the record, please, sir.
J. Dingman.
All right, Mr. Dingman, your court's understanding is you're going to plead no contest to the charge of disturbing the peace. That is a misdemeanor punishable by up to 90 days in jail, $500 fine plus court costs. Do you understand that?
Yes, I do.
All right. Do you understand what a no contest plea is?
Yes, I do.
All right, two things about it I have to make sure that you understand. First of all, it means that you're not further desirous or wanting to contest this charge. You understand that?
Yes, I do.
Second thing is that for purposes of sentencing, the court's going to treat you the same as though you had pled guilty to the charge. You understand that, sir?
Yes, I understand.
Basis for the no contest plea?
Lack of recall.
All right. To that charge, how do you plead, sir?
I pleaded guilty.
Mr. Dingman, no contest is what we discussed. You'd have to state no contest if that's what you wish to do today.
No contest, please.
Thank you.
You understand that by pleading no contest, you will not have a trial of any kind.
Yes, I understand.
You signed or went through with your attorney an advice of rights form?
Yes.
Do you have any question regarding any of those rights?
No.
The rights under paragraph 5 are your trial rights. You understand that you're giving up those rights as well as all the rights that are on that form?
Yes, I do understand.
You understand you're giving up your right to appeal of right?
Yes, I understand.
Are you on probation or parole?
No.
Has anybody promised you anything other than what's been stated here today to get you to plead?
No.
Anybody threaten you or coerce you?
No.
You're doing this voluntarily?
Yes.
And of your own free will?
Yes, I am.
All right. The court has been provided and has reviewed Pittsfield Township Department of Public Safety report for their case number 259660. Any objection to the court having reviewed that report?
No objection.
No.
Upon a review of that report, the court does find that there's a sufficient factual basis in which the court could determine the defendant's guilt of this offense. Mr. Dingman, I'd have to advise you that if between the time of my acceptance of your plea and the time of your sentencing, if you commit misconduct as defined by the Michigan court rules, you would not be entitled, the court would no longer be bound by any sentence evaluation or recommendation. You understand that, sir?
Yes, I understand.
You understand also you would not be entitled to withdraw your plea.
Okay, I understand.
Understand that? Okay. Counsel, are there any other promises, threats, or other inducements which have led to this plea?
No, Your Honor.
And has the court complied with the court rule, and would it be proper to accept this defendant's plea?
Defense is satisfied.
People are satisfied.
Court will accept the defendant's plea of no contest to count 2. Count 1 is dismissed. Pre-sentence investigation and report is ordered at 14A1 probation. Sentencing in this matter will be
October 8th at 9 a.m.
October 8th, 2025, 9 a.m. before me.
Your Honor, if I may address bond briefly on my client's behalf.
No, I was talking about that.
Thank you.
What happened this early, but go ahead.
Your Honor, I'm asking the court to consider a release on a personal bond. I did have a chance to meet with Mr. Dingman. This is the only matter holding him. He does have a cash bond on a 14B case that my understanding is to convert to a PR if this case is converted to a PR. It's $1,000, 10% right now. Mr. Dingman has been complying with the probate order. He's been receiving his medication. This is a 90-day misdemeanor he pled to, and he currently has 55 days credit for time served. Based on that, I would ask for consideration for, or if not, maybe after he completes his PSI in custody.
Response.
Your Honor, we would leave it up to the court's discretion. He is currently undergoing treatment.
All right. What I will do is I'll grant your request and deny your request in part. His bond will become a PR after he's in probation.
Understood.
All right.
Thank you. Thank you, Judge.
Thank you. In part. Court does call the case of the People versus Dalton Hall.
We're ready then.
Good morning, Your Honor. Laura Lundberg on behalf of the people.
Good morning.
Lauren Brown, Deputy Chief Public Defender, appearing with and on behalf of Mr. Hall, who approaches from my right. State your name for the record.
My name is Dalton Hall.
Thank you.
Your Honor, today is the date and time set for the probable cause conference. We just received some further information in this case. We would ask for a week adjournment so that we can process that and talk about options for my client. He needs to be informed of certain developments in this case.
All right. Just procedurally, as to he's not been arraigned on counts 5 and 6. I'll wait formal reading of those counts. And
yes, sir.
He stands mute.
Yes, sir.
Defendant having waived formal reading, standing mute as to those counts. Court will enter a not guilty plea.
Thank you.
Any objection to the 1 week adjournment?
No, Your Honor. I would also at this time move to dismiss counts 1 and 2 as they were corrected by adding those amended counts.
Gotcha. Okay. So I will dismiss counts 1 and 2 in this case. No objection, I'm presuming this.
No objection. Thank you.
You want a 1 week adjournment?
Yes, please.
So do you feel at your age, you don't have to give me a green sheet? No, that's okay. It's all right. I don't need an answer to that. I'll wait.
Let me okay. I got one for you. I get you one.
Probable cause conference in this case will be adjourned to the 25th.
All right. Thank you very much, Your Honor.
Continue. Court calls the case People versus Timothy Flood.
Ready, Your Honor.
Good morning, Your Honor. Joe Simon on behalf of Mr. Flood, station agent Timothy Flood.
And at Mr. Simon's age,
Ouch.
got me this year.
Mr. Vincent and Mr. Goldstein and I were having that discussion, Your Honor, and it is official that I cannot deny that age anymore. So I think I have to concede.
Very good.
In this case, Your Honor, I made a proposed resolution to Ms. Willenbring the other day that she's going to consider, we're asking the court to adjourn. Well, there's no commitments. I'm sure she's going to add that in a minute, but she's going to at least consider what I've offered.
All right. I can go to the 30th or the 9th.
The 9th, I'm traveling, Your Honor, and I don't know if just check the 30th real quick. I can do the 30th. Thank you.
Probable cause conference will be adjourned to September 30th, 2025, 9 a.m. Bond continued.
Thank you, Your Honor.
Thank you.
All right, Tim, you can get out of here. All right, see you.
Court does call the case of the people versus Winona Harvey.
We're ready. So that'll be. Lauren Brown, Deputy Chief Public Defender, appearing with and on behalf of Ms. Harvey, who approaches.
Can you state your name, ma'am?
I don't know my name.
You don't know your name?
No.
Okay.
I can't use my first last name and I was born no middle name.
Okay. All right.
My family, nothing.
What are we doing?
Your Honor, this matter is set for a competency review. We do not have an updated report. Does the court have an updated report?
I do not. I have not received a report.
And I believe it might be appropriate for us to wait to get an updated report.
You know my name?
Yes.
Winona Harvey.
Got it.
I'm appearing with and on behalf of Ms. Winona Harvey.
All right. Has anybody contacted the forensic center to see when a report might be forthcoming?
We've gotten no communication on that.
Ms. Lowe?
Yes, Ms. Akinruli had Akira Akinruli had contacted prior, and initially they had said that the report would have been done by today, which is why we had it set.
Why we had it set for today. That's what I thought.
Still waiting.
All right, what I'll do is this, I'll adjourn the competency hearing to October 30th. We will move that date up if the report comes in pursuant to the statute. So October 30th, 2025, 9 a.m.
Thank you very much.
All right.
Okay.
Bond continued.
Thank you.
Let's call the case of People versus Jordan McKinney.
He was here earlier. Look out in the hallway. David I. Goldstein, appearing on behalf of the defendant.
It'd take a while.
State your name, please.
Jordan McKinney.
Your Honor, I believe that the discovery has been provided. We're asking the matter be set for preliminary examination.
Yeah, for the record, I was prepared to make a very reasonable offer. It doesn't sound like we are in that stage. So we'll move on. Thank you.
Well, I will consider that between now and the date of the exam. I'm considering the
That would
offer.
make me very good. Thank you.
Okay. Guys are done. Covering everything completed. Would the people have their witnesses? We're on the 30th.
Yes.
Sorry, what date, Your Honor? Sorry.
People have their witnesses available September 30th.
I believe so, Your Honor.
Preliminary examination in person will be set September 30th, 2025 at 9 a.m. before Judge Walker. The Wilkins. That's called the case of People versus Justin Scott.
That's felt for the people.
Right, Judge. Torshio Feaster, Assistant Public Defender, on behalf of Mr. Scott, who's approaching the podium. Mr. Scott, please state your name for the record.
Justin Scott.
Thank you, Judge. I spoke to my client. I reached out to the people on this matter. We are still negotiating. I'd ask for a 2-week adjournment, please.
I have 1 and 3.
Oh,
Well, I have the 30th.
Let's go the 3.
Pardon?
Let's do the 3, please, Judge.
The 9th.
Yes, Judge, because I'm going to ask you now for a release to treatment.
Probable cause conference will be adjourned October 9th, 2025, 9 a.m. Bond will continue. If you send over the release treatment order, I will.
Thank you, Judge.
All right. Thank you. Thank you. Court calls the case of the People versus Christopher Coffey. Miss Wiley, approach, please.
Good morning, Your Honor. Jay Grant Miller, P58658, on behalf of Mr. Coffey, who I have not been able to locate.
Okay.
Oh,
I'm talking. Well, good morning. Good morning. Who's the prosecutor on this?
It's ringing for people.
God, I hate to do this so early. Did you pull those?
I can bring it for you.
I don't have them. Can I see counsel and back just momentarily? Court is staying in brief recess, everybody. I want
Good night. Thank you very much.
What happened?
Ashley Feltus for the people.
Assistant Public Defender Chelsea Vergils with and on behalf of Anthony Williams, who is in custody.
I have this as an AG case.
I was looking at Jeffrey Williams, Your Honor. I apologize.
All right.
Anthony Williams. Here.
All right. State your appearance, please.
Jesse Green, Special Assistant Attorney General, here on behalf of the people, Your Honor.
He's in custody.
Yes, Your Honor, we're planning on waiving the preliminary exam. I actually didn't sign the form.
No objection, Your Honor.
Anthony Williams.
All right. He's waiving preliminary examination.
Yes, Your Honor.
Sir, is that a correct statement?
Yes, sir.
You understand that that's a proceeding where the people would have to show by probable cause that the offense alleged was committed and that you committed it?
Yes, sir.
You understand you'll not have that hearing. You'll proceed to circuit court for further resolution.
Yes, sir.
People also do waive their right.
Yes, Your Honor.
Preliminary examination having been waived, defendant's bound over on a single count.
We acknowledge receipt of the information, waive its formal reading, and stand mute.
Defendant having waived formal reading, standing mute, court will enter a not guilty plea. Pretrial will be set for
September 30th at 1:30 with Judge McNally.
September 30th, 2025, 1:30 before Judge Combs. Bond will continue.
Thank you, Your Honor.
Thank you, Your Honor.
Thank you, sir. Court does call the case of the people versus Rayshawn Dawson.
Morning, Your Honor.
Morning, Your Honor. Sam Bernstein with and on behalf of Mr. Dawson. Mr. Dawson, could you please state your name to the court?
Rayshawn Dawson. Thank you.
Your Honor, we're asking for an adjournment, please, to review discovery.
Without objection, probable cause conference will be adjourned October 9th, 2025, 9 a.m. Bond continued.
Thank you, Your Honor.
Thank you. Court calls the case People versus Douglas Brown.
Good morning, Your Honor. Michael Vincent on behalf of Douglas Brown. Mr. Brown, state your name.
Douglas Steele Brown, Your Honor. Excuse me. Good morning.
Good morning. Your Honor, this is a day probable cause conference, and I'm going to request an adjournment. We still have discovery to get.
Well, where's your? Okay. Yeah, exactly. I lost you there and I said, I'm not asking Vincent. Will October 9th work? All right.
Thank you, Your Honor.
Probable cause conference will be adjourned October 9th, 2025, 9 a.m. Bond will continue. Thank you. Court calls the case People versus Terrence Ginyard.
Jesse Green, Special Assistant Attorney General, here on behalf of the people, Your Honor.
Thank you.
And Assistant Public Defender Jay Bellinger on behalf of Mr. Ginyard. Mr. Ginyard, can you please state your name for the record?
Terrence Ginyard. Go ahead.
And Your Honor, I am asking for an adjournment today. I have reached out to AAG Williams on this matter. I wasn't aware that a different AG might be covering today's case. So I am just seeking an offer from them. I did just get good contact information from my client as well. So I'm just seeking a 2 to 3 week adjournment.
Without objection, I'll adjourn this to October 9th, 2025, 9 a.m.
Your Honor, may I ask that we schedule for something after the 10th? We're concerned about a government shutdown, which would mean we wouldn't be able to appear for hearings.
Hold it. That state government shut down?
Yes, Your Honor.
Hold on a second.
Unfortunately.
But I'm a county.
I know you are, Your Honor, but.
No, I was just looking for time off. I'm just.
They wouldn't.
So you need something after the 10th, you believe?
Yes, Your Honor. Thank you.
So, well, he's out of custody. I'll tell you what, because I don't know what that means. I maybe have to read up on that. Let me go to October 23rd.
23rd. Thank you, Your Honor.
Yeah, all right. October 23rd, 2025, 9 a.m. Bond continued.
Thank you, Your Honor.
Thank you.
Who else? You county?
Location, date, time. I need to be here next. Okay. And I will reach out with your new number as soon as I can.
All right.
Thank you. All right. Take care.
Yes, go ahead. Court calls the case People versus Quentin Coleman Ebersol.
Good morning, everyone. Assistant Prosecuting Attorney.
Your Honor, good morning. Joe Simon on behalf of Mr. Ebersol. State your name, please.
Quentin Coleman Eversole. All right, I have before me a plea form. That's what we're doing,
Yes, Your Honor.
indicating that he's going to plead no contest to 3 charges. First charge is count 3, larceny 200 to 1,000. That's a misdemeanor punishable by up to 1 year incarceration. Also, intentionally dissemination, of sexually explicit visual material, 93-day misdemeanor, and count 5 of domestic violence, also a 93-day misdemeanor. Upon his successful plea to those 3 charges, counts 1 and 2 would be dismissed. There is an agreement that sentencing to be determined by probation, and that's the court's full understanding of the agreement. Is that correct?
That's correct.
Your Honor, that my client's ready to enter those pleas. Because he was in custody, I read to him all of the forms and he authorized me to sign on his behalf, and I reviewed them again with him this morning.
All right, very good. May I have him sworn?
Raise your right hand. Do you solemnly swear and affirm the testimony you're about to give will be the truth, the whole truth, and the truth so help you God?
Yes, I do.
State your name.
Speak a little louder.
Quentin Coleman Eversole.
All right. Sir, it is this court's understanding that you are going to be pleading no contest to 3 charges. Is that correct?
Yes, Your Honor.
All right. The first charge is count 3 of larceny 200 to 1,000. That is a misdemeanor punishable by up to 1 year incarceration, a $2,000 fine plus court costs. The fine could be increased at 3 times the value of the property taken. If that's greater than $2,000, that would become the maximum fine. You understand that, sir?
Yes, Your Honor.
Also, then count 4, which is the dissemination of sexually explicit visual material. That is a misdemeanor punishable by up to 93 days in jail, a $500 fine plus court costs. Do you understand that?
Yes, Your Honor.
And also then count 5, the charge of domestic violence. That's a misdemeanor punishable also by 93 days in jail, $500 fine plus court costs. Do you understand that?
Yes, Your Honor.
All right. Do you understand what a no contest plea is?
Yes, Your Honor.
All right. 2 things about it. I have to make sure that you understand. It first means that you're not further desirous or wanting to contest these 3 charges. You understand that?
Yes, Your Honor.
The second thing is that for purposes of sentencing, the court would treat you the same as though you had pled guilty. You understand that?
Yes, Your Honor.
You also understand, sir, that while I'm taking your plea, I would not be your sentencing judge. And you would be sentenced by Judge Freshour in the 14A4 District Court.
Yes, Your Honor.
All right. Basis for the no contest plea.
Potential civil liability, Your Honor.
All right. Sir, to the charge of larceny 200 to 1,000, how do you plead?
No contest.
To the charge of intentional dissemination of sexually explicit material, how do you plead?
No contest.
To the charge of domestic violence, how do you plead?
No contest.
Do you understand that by pleading no contest, you will not have a trial of any kind?
Yes, Your Honor.
All right. You went through an advice of rights form and had your counsel sign that on your behalf. Is that correct?
Yes, Your Honor.
Do you have any questions regarding any of the rights on that form?
No, Your Honor.
There's a copy on the podium. Please look at paragraph 5. You understand that because you're not having a trial, you're giving up those rights as well as all the rights that are contained on that form.
Yes, Your Honor.
You understand you're giving up your right to appeal outright.
Yes, Your Honor.
Are you on probation or parole?
No, Your Honor.
Has anybody promised you anything other than what's been stated here today to get you to plead?
No, Your Honor.
Anybody threaten you or coerce you?
No, Your Honor.
You're doing this voluntarily
Yes, Your Honor.
and of your own free will.
Yes, Your Honor.
The court has been provided and has reviewed Michigan Department of State Police report for their case number 5269-25. Any objections to the court having reviewed that report?
No objection from people, Your Honor.
No, Your Honor.
Based upon a review of that report, the court does find that there's a sufficient factual basis in which the court could determine the guilt of the defendant with reference to these 3 charges. Sir, I do have to advise you that if you commit misconduct as defined by the Michigan court rules between the time of the acceptance of my plea and the time of sentencing, that you would not be entitled to withdraw your plea, and the court would not be bound by any sentence recommendation. You understand that, sir?
Yes, Your Honor.
All right. Counsel, are you aware of any other promises, threats, or inducements that have led to this plea?
People are not here.
No, Your Honor.
All right, and have I complied with the court rule, and would it be proper to accept this defendant's plea?
People are satisfied.
Yes, Your Honor.
Court will accept the defendant's pleas of no contest to counts 3, 4, and 5. Counts 1 and 2 are dismissed. Pre-sentence investigation and report is ordered at 14A4 probation. Sentencing in this matter will be
September 25th at 10:30 a.m.
September 25th, 2025, 10 a.m. before Judge Rush Hour.
Your Honor, may I address bond? And with that hurried date, I'm telling my client, I didn't mean to take a minute to talk one thing. About just over 3 weeks ago, Your Honor, my client turned himself in on the court, revoked his bond. He had a $25,000, 10% bond originally. He admitted violating his bond by placing his call to his former spouse, or estranged spouse. And she contacted the authorities, and obviously that's how he's in. I'm asking the court to consider reinstating that bond. The amount of time he served is pretty substantial, but he knows he earned it. He wants to get back to work. And he was on a GPS tether before, and he certainly would wait to be tethered again if released.
Response.
Your Honor, I believe it's in the court's discretion. I will say people are very concerned about the behavior of this defendant, not only as the basis for the offense itself, but then violating it after the offense occurred and after he was specifically told what the conditions were. This is a situation where we have no, I think it's best left up to the PSIR. We would be more comfortable with staying in custody until the report has been done. And then, of course, they can make that determination and recommendation to the court. But at this stage, there are too many concerns and they're adding up to there to be an unsafe situation for this victim.
I'm going to deny your request to change his bond once certainly the pre-sentence investigation is done and you got a relatively quick sentencing date. Certainly Judge Freshour can make that decision. At this time, but motion for bond reduction is denied.
And I apologize, Your Honor, the court will we have a change in address. Was that made already or should we approach it?
Change in address of.
For the no contact.
That should be communicated directly to community corrections. Well, actually, we're going to have the no contact. If that can be provided in writing, we'll make sure that the file is updated. Thank you. Court does call the case People versus Imbe. Is it Indicate? Imbe.
Good morning, Your Honor. Assistant Public Defender Davi Leba for Mr. Ndiaye.
Yeah. Jesse Green, Special Assistant Attorney General on behalf of the people, Your Honor.
All right. He's waiving preliminary examination.
Yes, sir. He has executed waiver form, which I provided to the court.
Sir, is that correct? You're waiving preliminary examination?
Correct.
You understand that that's a proceeding where the people would have to show by probable cause that the offenses alleged were committed and that you committed them.
Right.
You understand that?
Yes.
You understand you will not have that hearing and that you'll proceed to circuit court for further resolution.
Yes.
People also waive their right.
Yes, Your Honor.
And Your Honor, I do just want to put on the record that we're waiving with an agreement of an offer available with a delayed sentence.
That's correct, Your Honor.
Preliminary examination having been waived, defendant is bound over to circuit court on both counts.
Thank you, Your Honor. We acknowledge receipt of the information and waive formal reading. Enter plea of mute at this time.
Defendant having waived formal reading, standing mute, the court will enter a not guilty plea. Pretrial will be set for
November 6th at 1:30 with Judge Slay.
November 6, 2025, 1:30, Judge Slay.
Thank you, Your Honor.
Bond continued. Thank you.
Thank you, Your Honor. Have a great day.
You do the same, sir. Court does call the case of the People versus Dwayne Stevenson.
Good morning, Your Honor.
David I. Goldstein, appearing on behalf of the defendant.
Your name, sir?
Dwayne Stevenson.
Thank you.
Your Honor, I believe I have all of the preliminary, discovery in this matter. We ask the matter be set for a preliminary examination.
People have their witnesses available the 30th.
I'll do it, that's you.
All right. Preliminary examination. We set September 30th, 2025. At 12 noon. That's before me.
I'm sorry, did you say 12 noon, Your Honor?
Yes, sir.
Mr. Boyd walked into court facing a Class A misdemeanor charge of deadly conduct, but this hearing ended with a sentence that gave him a major opportunity to avoid a permanent conviction. The court confirmed that the state had elected to proceed on the lesser included misdemeanor charge, and Mr. Boyd entered a guilty plea. The judge carefully asked whether he was pleading guilty freely and voluntarily, and whether he was pleading guilty because he actually committed the offense. After confirming that he understood the documents he had signed and the consequences of the agreement, the judge explained that the deal called for 1 year of deferred probation and a $500 fine. The judge then explained the biggest benefit of the agreement. If Mr. Boyd successfully completed probation and followed every condition, he would avoid a conviction on his record, and the case would ultimately be dismissed. But there was also a serious warning. If he violated the conditions of probation, he could be brought back into court, found guilty, and face up to 1 year in county jail. So although the guilty plea sounded like the end of the case, it was actually the beginning of a 1-year test. Mr. Boyd now had an opportunity to prove that he could follow the court's rules and walk away without a conviction. The judge also made sure he understood that the agreement included a waiver of his right to appeal. After accepting the plea, the judge directed him to meet with probation so he could receive all of the paperwork and understand exactly what was expected of him. The message from the court was clear. The judge was giving him a second chance, but that second chance came with conditions, and breaking those conditions could completely change the outcome. But the courtroom took a much more serious turn in the next major case. Harold Denton was facing a motion to revoke his community supervision after originally receiving a 10-year prison sentence that had been probated for 10 years for assault on a peace officer, a second-degree felony. The motion alleged multiple probation violations, including repeatedly failing to report to the probation office, failing to provide updated contact information, failing to enter a mental health caseload, failing to complete a battering intervention program, and failing to successfully complete required outpatient aftercare. When the judge went through the allegations one by one, Denton admitted that several of them were